Good afternoon. Please be seated. We're here at the time set for oral argument in file number 2025-0450, Katie Lynn Porteus versus North Dakota Department of Transportation. Counsel for the appellant is Thomas Murtha, and counsel for the appellee is Grant Ellenson. Sitting this afternoon are Justices Jared Tufte, John Jensen, Douglas Barr, Mark Fries, and I am Lisa Fair-McEvers. And before we begin, Mr. Murtha, I would like to take time to welcome the class from Fargo North, the criminal justice class, and their advisor, Melissa Evenson. So welcome to our oral argument this afternoon. Mr. Murtha, when you're ready, you may proceed.
May it please the court, Chief Justice McEvers. My name is Thomas Murtha. I represent the appellant, Katie Porteus, in her appeal from a decision of the North Dakota Department of Transportation suspending her North Dakota driving privileges. In this particular case, the facts are not in dispute. Ms. Porteus approached a stop sign, approaching a stop sign, stopped at the stop sign, signaled a left-hand turn after she stopped. Vehicles went in front of her. She proceeded through the intersection with her turn signal on, turning left, and was stopped. The law enforcement officer was interpreting North Dakota Century Code 391038 subpart 2. And we lay out in our brief what that is, but it says a signal of intention to turn, move right or left, or merge into or from traffic must be given continuously during not less than the last 100 feet traveled by the vehicle before turning. When you read that statute and you don't take words out, it prevents an absurd situation where, for example, if an individual is parked on the side of the road and needs to leave that parking spot and enter traffic, that vehicle does not have to travel 100 feet before it can turn. The terms included in 391038 that specifically point out during traveling specifically allow Ms. Porteus to have completed that turn exactly how she did, legally. She came to a complete stop at the stop sign. She's no longer traveling. Once she begins traveling, she's already activated her turn signal. So she stops, she's not traveling. She activates her turn signal, she begins her turn. The statute only required her to activate that turn signal during the last 100 feet traveled. In other words, going back to the point where she stopped. That standard is objective. It can be applied to every situation on the road for every vehicle. The law enforcement officer never has to subjectively determine whether or not there was 100 feet available. In this particular case, you have the transcript from the hearing conducted before the Department of Transportation. The officer interprets the statute for Ms. Porteus when she's at the stop sign one way, and then interprets it a different way if she was pulling out from a parking spot, indicating that he thought he was determined whether or not there was this 100 feet available or not.
Mr. Murtha, you agree that we apply an objective standard. The officer's subjective intention or how he interprets the statute is immaterial to our analysis. You agree?
I agree. It's completely irrelevant.
And you would have us rewrite this statute to add, except when stopping.
No.
How?
I wouldn't have you rewrite it. I'd leave it just as it is. It is the department that's asking you to take words out to reach the conclusion that they have. That somehow, if I stop, that I'm traveling, when in fact that's impossible. If I stop, I'm not traveling. So the distance goes based on what I'm actually traveling, not some subjective interpretation of what the officer thinks happened.
But counsel, unlike
Yes.
someone pulling out of a parking lot who has not traveled at all, she traveled 100 feet before turning. Correct? She was driving down a road.
Yes. And then he
So-
came to a complete
So
stop.
the light under this statute, it should have been continuous for those 100 feet.
Okay. Now, look at the statute. That's not what the statute requires. The statute specifically talks about during not less than the last 100 feet traveled. You can't take that out of the statute. That has to stay there. She stopped. So she's traveling, she stops, she's not traveling anymore, she stopped, she signals, and
So
then
the
she
last
turns.
100 feet traveled were the 100 before she stopped, correct?
Yes,
Okay. And was her turn signal on during those 100 feet traveled?
before she stopped, no. Her signal came on after she stopped at the stop sign and then initiated her turn.
Is the term traveled defined? Are we using a plain meaning? It seems like the word that you're using would be, moving would be a better word than travel, because if I'm traveling, in a plain usage of the word, I'm traveling and I pull over and I go on, I'm traveling the entire time, even if I take a small break. I'm still traveling. I'm not moving the entire time, but I am traveling from point A to B with that stop in the middle. So are you trying to make that word mean moving instead of traveling?
I didn't think I was doing that, but I understand your point. If you interpret that word that way, traveled, what does travel mean? And I don't see it defined in the statute. I think we run into a problem, because how then, if I do park and I do want to pull out, or I'm in that situation where I haven't moved or traveled 100 feet, interpreting the statute that way creates the circumstance where I can't legally or safely move my vehicle. I'm stuck. I have to sit there and wait for a law enforcement officer to direct me, because, there's the exception for, law enforcement can direct you around a traffic signal or for other reasons. And you're interpreting the statute that way. And I'm saying that that's an absurd interpretation. I'm not grafting onto it. Creates the situation that's going to happen to everybody. And I see this a lot in a lot of other cases where it's impossible to do that.
Well, hypothetically, Mr. Murtha, if we adopt your interpretation of the statute, if we agree with you, wouldn't that be unhelpful to all the other drivers who are driving opposite of the person who's stopping? Coming to a stop sign if someone doesn't use a blinker might mean that someone else who has the right of way, depending on which way you're turning, would have to wait, or there could be a collision because the blinker wasn't used.
Thank you. And that I tried to address that in my brief. So looking at that particular scenario, I did not argue that. I'm not arguing that. I'm arguing that she had to signal, okay? But she can signal at the point where she's stopped, and then she begins traveling because she was signaling then. That's what the statute requires. Not that I'm arguing somehow you can avoid signaling a turn. I'm saying that you begin signaling your turn legally under this statute from the point you are stopped as you begin traveling. And that from whatever point you're turning, measuring backwards, you need at least 100 feet of continuous signal to do that. Reading it another way grafts on this requirement that somehow you have to go 100 feet before you can turn. And I don't think anybody wants the statute to say that or imagine that it does. Yet, that's what the department is arguing. And I'm saying simply reading the statute, don't take the words out. Don't try to create this paraphrase of what it says so it's convenient. Actually read it. Include that. Why would the legislature then not just, cut to the chase and just say, a signal must be given continuously 100 feet before turning? That's not what it says. But that's what the department wants you to say it says. It says a signal must be given continuously during not less than the last 100 feet traveled by the vehicle before turning. Why would the legislature write it that way if it didn't mean what I'm trying to point out that it means? Writing it a different way creates the circumstance that the department is talking about. That's not what it says.
So your argument depends on any stop at a stop sign or a light to divide two different instances of traveling. Is that right?
Yes.
Okay. So I want to explore your parallel parking analogy a bit, because it seems like parking might be different than stopping in the flow of traffic. Because usually you get out of the vehicle. There's a bigger break in traveling in that circumstance, isn't there?
Of course, that can always happen. You could stop and get out. Maybe you don't stop and get out. I think that's a red herring for what we're trying to accomplish. I think that the way the legislature wrote it, this is really easy. You come to a complete stop, you activate your turn signal, and you begin your turn. You are turning legally the way the statute's written. And that applies to every single situation. We don't need to do any verbal gymnastics to fit a particular situation under that umbrella. It's already been provided by the legislature. I think that that ultimately is the only logical way you can interpret the statute, unless you want to shade this towards, yeah, we can just stop anybody from anything. And I mean, at a certain point, we come to, reasonable articulable suspicion. I mean, that is a low bar. But at this point, we can't have that, I guess in Heinen they talked, that sloppy study of the law. And that's what I'm trying to point out, is that the department keeps paraphrasing what this statute says, 391038 subpart 2. And I think that's in error. I think that when people are driving and in situations to make it possible to do and not create ambiguity and anxiety, that a driver should feel secure in the fact that when they come to a complete stop, they can initiate their turn signal and turn. That they don't have to worry about, okay, I'm at this stop sign. How far back did I travel now?
You seem to want a driver to be able to stop at a stop sign and then change their mind, perhaps, which also seems a very practical concern, wouldn't it be?
Yes, and that's where I was going. If we create a situation where you're saying no matter what, you have to go 100 feet before you can turn, and I don't want to put words in the department's mouth, but that sounds like what they're arguing. That creates an untenable situation for drivers, or at least one that creates a sense of anxiety. Whereas I don't think that the legislature included all of these words for no reason. They must have had a reason. And that reason logically concludes that if you come to a complete stop, that's the defined term for traveled. Now, I understand that we want to, is it moving? Is it traveled? How is it defined? And again, I go back to how do we avoid the ambiguity in that interpretation? And again, everybody can function based on how it's actually written by using the defined term, the undefined term traveled as just that. I stopped, I'm not traveling. I know when I'm stopped, I'm not moving. I know when I'm stopped, I'm not traveling.
This is an ordinary meaning question, though, isn't it?
It is, yes.
So the Chief Justice's question about wouldn't a typical person think they're continuously traveling even through stop signs when they make a complete stop?
I don't.
Is that our inquiry here? What does the statute mean to a typical driver? Or is it different than that?
Okay, so I actually have this situation arise in the real world many times. And I'm sure that this court has seen many times where we have had this particular circumstance, although I have yet to see this case on this issue actually addressed on point. But I don't know of anyone who thinks that they can't stop at a stop sign, initiate their turn signal and turn, and thinks that that's illegal. Anecdotally, I've never encountered that. Yet, here we are.
Well, you just mentioned that this statute hasn't been interpreted, and you haven't addressed the line of cases like Hirschkorn and Schuler, where an officer doesn't have to there doesn't have to be an actual violation of the statute.
Correct.
As long as they reasonably believe that they had justification. So would you address why it's not? I expect you're going to argue why it's not.
I wrote it
Objectively
in my
reasonable?
brief.
Yeah.
It's both in my main brief and my reply brief, but yes, I'll bring that up. So let's talk about what is reasonable here. So an officer, and this particular officer uniquely said he was unfamiliar with our century code and with this particular statute, and thought that it could apply one way if you're coming out of a parking spot and a different way if you were in Ms. Porteus' situation. I think that that is that slipshod study of the law that Heinen warned us about. I think that you can't let that slide. That if you are duty-bound to enforce the laws of the state of North Dakota, please know what they mean. Please have paid attention to them.
How can we expect an officer to know what a statute means that hasn't been interpreted? And we're having this
Oh.
debate about what the plain meaning is.
He didn't even know what the statute was. That's the problem. So it'd be one thing if he says, yeah, I know what that is, and I think it means this, or I interpreted it that way, but he did nothing. He had no training on it. I didn't even think about it.
But he gave it as the reason for the stop, failure to use a signal, so he knew there was a statute somewhere.
Yeah, he knew there was a statute somewhere that did something about something, but
But he was a municipal officer charged with the obligation of enforcing municipal ordinances. You're not citing any of the municipal ordinances either.
yeah, there's no municipal ordinance that authorized that stop. He had to rely on 39-1038-2. That's what he had to rely on. And I was pointing out that in cross-examination of him, that maybe he's not familiar with that statute actually says, because it appeared to me that he was using that paraphrase shortcut, right? That I talked about. If you take out, that verbiage and you say that a signal must be given continuously 100 feet before turning. And then I paraphrased it. I took out all that extra verbiage that the legislature must have stuck in there for no reason. And I just say it that way. And he's right. That's not what the statute said. And I don't think we can just arbitrarily remove words from a statute when they dramatically affect how a driver is supposed to navigate this particular situation. So when I talk about whether or not this officer was reasonable, he for sure was not. And he pretty much admitted that or implied that when he doesn't even know what 39-1038 Part 2 actually requires.
Isn't the test a reasonable officer, not this particular officer?
It is a reasonable
If a
officer.
reasonable officer, knowing this statute, could believe it required that travel distance with the signal, then that resolves that issue, doesn't it?
No, I don't see how a reasonable officer can interpret a statute to create unreasonable circumstances when the plain language of it is designed not to encounter that. You can't interpret something to manipulate and shade it in your direction so you can stop anybody for anything. We have to have this, officers still have to look at this through an objective lens. They can't create ambiguity or subjective opportunities within the statute in order to promote their ability to stop someone based on reasonable articulable suspicion. Otherwise, we kind of throw in the Fourth Amendment and Terry stop. We just stop everybody for anything. We have to draw all lines somewhere. We have to, at some point, look at what the text of the statute actually says and what the officer is doing. And the officer here, he is not using the text of the statute to interpret it. He's using a paraphrased version. And Heinen doesn't allow that. That's that slipshod study of the law. You can't just say, well, anecdotally, I heard that the law is this other thing. No, you're duty bound to actually know what that is if you're going to limit somebody's, freedom. If I'm going to stop you, if I'm the government and I'm going to invade your space, well, you got to follow due process. You can't just skip over this. And sometimes we get dangerously close to doing that and we just let it go. And I'm trying to point out that this is what due process requires. At least go back and know the language of the statute before you take the stand in a hearing where somebody's going to lose their driving privileges in the state of North Dakota. You get suspended. That officer, even with everything shaded towards the department, at least he should know the language of the statute that he's using to stop you. I think,
In a
yes.
previous case relating to a roundabout with this statute.
Yes,
I wrote separately to say we should at least answer the question, so we're not stopping at the could a reasonable officer interpret this. Is that our obligation under your due process argument?
I thought so.
Whether you win or lose, shouldn't we just answer the question?
I thought so. I was 100% behind that and was really super frustrated. And in the real world, I think not doing that in the decision was a horrible mistake. I could go on, but I will limit myself. I really wish you'd do that here. Either way, don't just leave this hanging. Don't leave us hanging on this. It happens too many times. I have time reserved, and I just hit the mark.
Thank you, Mr. Murtha.
Thank you, Chief Justice.
Mr. Ellison, whenever you're ready.
Good afternoon, Chief Justice, Counsel, and may it please the Court. My name is Grant Ellenson, and I represent the Department of Transportation. The Department today asks this Court to affirm the hearing officer's decision to suspend Ms. Porteus' driving privileges for 91 days. This Court should affirm for two reasons. First and foremost, Officer Schroeder observed Ms. Porteus commit a violation under 391038 subsection 2. When she failed to signal during the 100 feet traveled by her vehicle before turning. And second, in the alternative, even if mistaken with the law, Officer Schroeder's interpretation of the statute was reasonable. In other words, his mistake of law was objectively reasonable. Starting with the first argument, the dispositive question here is whether Officer Schroeder had suspicion to stop Porteus' vehicle. The answer to that is yes, because Officer Schroeder observed Ms. Porteus operate a vehicle without utilizing a turn signal within the last 100 feet before she stopped.
Counsel, Mr. Ellison, what do we do with the many circumstances in which someone cannot travel 100 feet before turning? For example, someone in a parallel parking situation or who only driving 50 feet out from a parking lot. Does the statute exempt those, or how do we handle that?
Your Honor, I would believe that's when there's a situation where a vehicle does not have the opportunity to travel 100 feet prior to making a turn, that would not be a violation, and that's not the issue that. Because that's how you interpret it? I mean, does the statute exempt that anywhere? The statute requires the 100 feet of travel. So it would be common understanding that if the vehicle doesn't have 100 feet prior, they wouldn't be subject to subsection 2 of 3810.
So if they only can travel 50 feet, they have to have it on for 50 feet?
No, Your Honor.
Not at all?
It would only be present in situations when the length of their travel could have been 100 feet. The answer is yes, because Officer Schroeder observed Porteus operate a vehicle without utilizing a turn signal within the last 100 feet before she stopped and turned in violation of the plain language of North Dakota Century Code 391038-2. Specifically, subsection 2 reads, a signal of intention to turn must be given continuously during not less than the last 100 feet traveled by the vehicle before turning. Here, Porteus approached the intersection. During her approach, she did not signal. She stopped. She signaled only, and then after stopping, at the stop sign and before completing her left turn, did she signal? Officer Schroeder watched it happen from his position observing that intersection. Officer Schroeder testified at the administrative hearing that his reason for initiating the stop was, quote, Porteus' failure to signal 100 feet before the intersection. 391038 subsection 2's plain language as written is broad enough to encompass the factual situation before the court today. Because of the officer's direct observation of Ms. Porteus' traffic violation of the statute, there was a reasonable basis for the stop, and the department's decision should be affirmed. In the event that this court were to disagree with the department's interpretation of the statute, the stop was nonetheless proper because Officer Schroeder made an objectively reasonable mistake of law. And again, the objectively reasonable mistake of law is indicated through his testimony at the administrative hearing if this court is to not agree with the department's interpretation and to go with appellant's interpretation. It would be a reasonable, his mistake is objectively reasonable under Hine because his understanding of the law as indicated in his testimony is consistent with the plain language of 391038-2 as currently written.
Is there any other statutory context that would help us answer the question of whether a stop at a traffic control signal like a stop sign, whether that interrupts two discrete events of traveling or whether that can just be a part of one continuous event of traveling? What comes to mind, and I'm sorry, this is catching him perhaps flat-footed, the department recently had a statute relating to texting while driving a couple of years ago. Mm-hmm. And if I remember correctly, if I'm stopped at a stop sign or a stoplight, I'm still in violation of that statute if I'm using a cell phone to send a text message or to receive a text message from somebody. I don't know if that has similar wording, but does that sort of a context where the department at least views that as part of traveling, even though you're stopped? Does that help us answer the question here?
I say it would, Your Honor, yes. And that's the department's position today is travel encompasses the whole approach of the stop and thereafter, as you indicated before. So there isn't, it's not the department's position that there's somehow a tolling of the 100-foot requirement when a stop occurs. It's the travel, again, is continuous through a driver's approach up to the intersection, through their process of executing a turn, which involves slowing prior to making that turn. And it's not like a driver ceases to be a driver the moment they put their foot on the brake.
Counsel, in 2021, the legislature modified this statute. Subdivision 2 previously said an intention to signal, an intention to turn right or left when required must be given not less than 100 feet. Is this court to draw something from the legislature's decision to remove the language when required from the statute?
Just to confirm your question, Justice Freeze,
Sure. What subsection 2 previously said is that when a vehicle is going to turn left or right on a highway, a signal under this section, when required, must be displayed for not less than 100 feet. That when required language is no longer in the statute. Does that evidence some intention of the legislature to address the arguments that you're providing here today?
Yes, Your Honor. I would say that the department's position would say that it would, because by taking out when required would remove any ambiguity that by having the current language stating continuously. So if it would say when required and continuously within the same phrase, that may lead to ambiguity. However, by having that word removed, or that phrase when required, would allow this court or what I would say is helpful to this court, that this is a requirement, it's a distance requirement of travel, not subject to tolling when a vehicle would stop.
Statute also authorizes a signal of intention to turn to be given by hand and arm signals. Are you aware of that statute?
Yes, Your Honor.
How is a police officer to know in hours of darkness whether the person is signaling or not? Because they may not be using a turn signal, they may be using a hand and arm signal.
Your Honor, I would suggest, or Your Honor, it's my understanding that the case before you today is involving turn signals on a vehicle and not hand signals. And that the issue today before you is,
I understand that. There's nothing in this record to suggest that the driver was using a hand and arm signal, but we're looking at overall reasonableness of police officers making stops for traffic violations, for turn violations. And signaling an intention to turn can occur in a number of different ways.
yes, Your Honor.
Mr. Ellenson, I'm curious, Justice Freeze has brought up the amendments that were made to the statute, and that I'm curious about the timing of those amendments. Did they occur, to your knowledge, before or after the Schuler case was issued? Because it's a 2021 case, and it looks like it's early in the year, but I don't see a date on it. Well, maybe there is a date at the end. Were the changes, modifications in response to that case or to the underlying case that they were aware of this issue with roundabouts?
In relation to the Schuler case, Your Honor,
Yeah, did the legislature change the statute because of Schuler? Were those modifications that Justice Freeze just mentioned, were they made in response to Schuler, if you know?
Your Honor, I'm unable to answer that question at this
Thank you.
time.
I can look it up.
In relation to Schuler, I guess just jumping into the case analysis with Schuler, again, that is only if this court is to disagree with the department's interpretation of 391038-2.
Well, it seems that Justice Tufte's separate might have been inviting some action by the legislature, and that was why I was curious.
Yes, yes, Your Honor. First, the department's position here is that we don't need to get in. This court does not need to go to the statutory interpretation because Officer Schroeder observed a violation of subsection 2. And additionally, it's the department's position that the statute at issue here is clear and unambiguous. The only way this court would interpret a statute or give its interpretation of a statute would be if there could be two reasonable results. Here, in this case, there's not two different reasonable. There wouldn't be two reasonable results based on the reading of the plain language of the statute. Here, Officer Schroeder stopped Porteus under a statute that says a turn signal must be activated during the last 100 feet traveled before turning. Officer Schroeder, like the officer in Schuler, could have reached an objectively reasonable conclusion that Porteus was required to use her turn signal within the last 100 feet her vehicle traveled before she stopped and made a turn. As the district court observed, his interpretation was, quote, tied to the statutory text. Therefore, this court should affirm because Officer Schroeder objectively made a reasonable mistake of law. There are no other questions. The department respectfully requests this court affirm the hearing officer's decision to suspend her driving privileges for a period of 91 days.
Thank you, Mr. Ellenson.
Thank you, Your Honor.
Mr. Murtha, it looks like you have 10 minutes in rebuttal.
Yes, Chief Justice. All right, wish I could have another half hour, but let's go back to talking about, what we mean by travel. I think that's important. If you look at how this is worded, right? And I keep going back to that. Let's, take that paraphrased version where we just take all that extra verbiage out, right? And we have a signal must be given continuously 100 feet before turning. And that's what you're saying when you're saying traveling includes the stopping, or it's just the act of getting from point A to point B and all the stuff that happens in between. Well, then why didn't the legislature just write it that way? But they didn't. They didn't. They included this other language specifically so that Katie Porteus could do exactly what she did, and that all of us could do exactly what she did, and it wouldn't be illegal, so that we could have circumstances where you don't have 100 feet. I mean, it seems obvious, and I don't understand why the department, at least couldn't just surrender that issue. It's obvious that this doesn't mean you have to have 100 feet before you can turn. It can't possibly mean that. We can't possibly think that the legislature was doing that to drivers in North Dakota. I should not have to go get a law enforcement officer to let me pull out from my parking space because I can't move 100 feet. I shouldn't have to get a law enforcement officer to help me navigate a circumstance, they're micro circumstances, where I don't have 100 feet. And then I gotta have, some special dispensation so that I can do that without getting a ticket. The legislature did not draft that statute to lead to absurd results. Yet the department keeps going down that rabbit hole, and they shouldn't. And law enforcement shouldn't, and we should not be doing that to drivers.
So I asked about the texting statute.
Yes.
The department knows how to write a statute that separates parking from stopping. It did in that statute.
Yes.
Defines traffic. Does that help us or not here?
I think it does. I think it helps us a lot, because you've got a circumstance where you're talking about something occurring within the vehicle, right? We're trying to regulate, that particular statute, we're trying to regulate conduct. We're saying, don't do this thing because it's super dangerous, right? And they're addressing it, they're pulling it out and saying that, in those stopped instances, you still don't do it. Now compare that to what we've got in this circumstance, right? We're talking about the distance traveled. And here, we're parsing that out specifically so you don't create these odd situations. You don't create a circumstance where I have to wonder if I can really pull out because I haven't gone 100 feet. And so it is important that we look at that. But beyond that particular issue, I'm asking this court, just look at the text, not the paraphrased version, just look at what it actually says. And think about, how do we as drivers navigate this reality if I'm wrong? If we do have to go 100 feet no matter what? And that's miserable. I can't imagine the legislature would do that. I can't. And when that law enforcement officer got up there, I was kind of gobstruck that he would say, what he did about not knowing the whole basis for his stop. And he honestly believed, I guess, that you had to signal 100 feet before the intersection. So that means that if there's an intersection where you don't have that available, he can stop you there in all circumstances. So he just has a free one.
Mr. Murtha, what is your position with respect to the statutory change removing that language when required.
Okay, I think that stems back, I think they made another change on that. The one required was part of a rewrite on that whole paradigm. I think that it's very relevant for what we're talking about because the legislature specifically made these particular elements and aspects of how you're to navigate that particular circumstance by using and focusing on that verbiage, the distance traveled, and the during language, when they didn't have to, if they were going to do the version of, it's 100 feet no matter what. So the when required, that refers back now to subpart 1.
It was in subpart 2, subsection 2.
It was in subpart 2, but it refers, if you look at subpart 1, it talks about, the reference to, when you do this, and that comes in to subpart 2. So I don't think that the based on that change, I do not believe that the legislature changed how we necessarily interpret that turn statute. I think that the net result is the same.
So they intended a meaningless revision to the statute is your position?
No, I did not say that.
So what was the intent of removing when required?
I think the when required was removed to take care of an ambiguity stemming from the roundabout decision. And that talking about circumstances when required, because, if you recall, what we were left with at that time was, okay, is it required or not? And our Supreme Court hasn't said. So that, I think the legislature was
But
trying.
there's a whole series of cases going back to the early 1980s where this court has said leaving an alley is requiring a signal, leaving an interstate highway to merge onto an off-ramp requires a signal. In virtually every case that I've looked at where this court has been asked to determine whether a signal was required, except City of Lincoln versus Schuler, where they just adopted the district court's analysis, they resolved the case on the decision of the district court. Every single case has concluded a signal is required.
Correct. And I'm saying a signal is required here. Absolutely. I'm not arguing that a signal is not required.
Well, your argument says it's not,
No, it isn't.
because if they stop and they turn directly from the stop, they haven't traveled, so they never have to put on the signal.
I did not argue that, and that's
Well,
not.
You're saying you're not arguing it, but your analysis only requires a signal when they travel. And if they stop and start turning, they haven't traveled at all before turning, under
Okay.
your analysis of the term traveling.
Okay. Let's take my analysis of the term traveling. They're stopped, not moving. I'm saying that if they are going to travel from the point of being stopped, they better have their signal on. And if they don't, then you go back and they get a ticket. So no, I'm not arguing that you can stop at a stop sign and that gives you free rein to just turn without signaling. I would never argue that. They have to initiate that signal. They have to do what Katie Porteus did. They're stopped. They turn on their turn signal, and when they're traveling, they're signaling the entire time. That is what she did. I'm not arguing that you get to not signal because you stopped. I am arguing that you signal when you travel. And if you have to interpret me saying travel means moved to get there, then that's what it means.
Mr. Murtha, with a little closer reading of some of the language of the Schuler case, the legislature did act before our case came out, and now they've had 2 sessions since then with no changes. What does that say to you, if anything?
Okay, so this whole idea that somehow our Supreme Court speaks to our legislature and they speak back, being intimately familiar with both, is just not reality. We could have a tremendous amount of action behind the scenes in the legislature, desperately trying to answer a decision that this court made and get absolute crickets when it comes to session. So it just doesn't happen. I wish it did, but it's not reality. There will be times where there are the votes, and it just doesn't happen to address something that the Supreme Court was like, look, this isn't our problem, this is yours, go fix it. It might be a long time before they go fix it.
And is that a reason why we should interpret the statute regardless?
Yeah, I think so. I think that irrespective of, our fear that we're going to step on the legislature's toes, if it's important enough, I think this court has and should take that on. I back that.
Thank you, Mr. Murtha, for your arguments this afternoon, and Mr. Ellenson as well. This case will be taken under advisement, as all cases are, and we are adjourned until 2:45 p.m.